The two documents that I will be talking about today are the Title IX and the Dear Colleague Letter. Both of them are created by the U.S. Department of Education and its Office for Civil Rights. Title IX is a federal civil rights law that addresses discrimination based on sex and sex-based harassment. Dear Colleague Letter, although still related to Title IX, is a guidance document that focuses specifically on campus sexual assault. The Dear Colleague Letter was enforced during the Obama administration, and it remains extremely controversial until this day. According to our current Secretary of Education, Betsy DeVos, this is a failed system. And she has a point. According to the Washington Post, since 2011, which is the year Dear Colleague Letter was created, more than 150 lawsuits have been filed against universities involving claims of due process violations during Title IX proceedings related to sexual assault allegations. However, in the 2 decades before that year, only 15 such lawsuits were filed against universities. It's evident the Dear Colleague Letter is flawed and it needs some serious reform. The main issue of the Dear Colleague Letter that I'm going to be talking about today is the preponderance of evidence standard. My claim 1 is, it deprives the accused student of equal treatment. Traditionally, many colleges and universities applied the clear and convincing evidence standard, which is a 75% likelihood of guilt. After Dear Colleague Letter is released, we now have the preponderance of evidence standard, which is the lowest possible burden of proof, and that is just over 50% likelihood. The Dear Colleague Letter states that this standard of proof is equitable under Title IX because it is consistent with the standard of proof in civil proceedings. Yet, in civil court cases, defendants have many protections not typically found in Title IX proceedings, the most significant one being cross-examination. In the Dear Colleague Letter, it explicitly states that they strongly discourages school from allowing the parties to question or cross-examine each other during the hearing. Besides cross-examination, says The Atlantic, there are other protections that Dear Colleague Letter fails to enact, and they are receipt of a specific written complaint, clear rules of evidence, knowledge of the testimony of adverse witnesses, the rights to discovery, and the calling of expert witnesses. So, that's quite a lot. Because the protections offered in civil court cases are not provided in Title IX proceedings, the standard of proof should not follow the civil court either. Under the current Dear Colleague Letter, the accused is subjected to injustice because they are faced with the lowest bar of proof together with no proper protection. Now, some may argue that giving the offender a chance to question an alleged victim directly may be traumatic or even intimidating. Although this is true in some cases, may I remind everyone that depriving the accused of due process or a fair trial will likely lead to unjust convictions. According to a case study from The Atlantic, a conviction will probably cost a student of his or her education, and an unjust conviction will cost a possibly innocent student of his or her education, and possibly lead to psychological trauma. Now, I just like everyone to imagine being expelled from college. Not only is that depressing, it will have profound implications regarding to your future and your career. And these consequences are much more significant than this arbitrary, depends on the case, traumatic experience. The second reason why the preponderance standard is inappropriate is because it contradicts the Supreme Court decision. In Grogan v. Garner, Supreme Court declared that the preponderance standard is presumed to be applicable in civil actions between private parties unless particularly important individual interest or rights are at stake. Usually, the consequence of confirmed sexual assault is expulsion, which is a matter of grave consequence. According to Geoffrey Stone, a professor at University of Chicago Law School, such an expulsion will haunt the student for the rest of his days, especially in the world of the internet. It may well destroy his chosen career prospects. College education, professional career, and as I previously mentioned, mental health are all important individual interests. Therefore, preponderance of evidence standard is inappropriate and should not be applicable to campus sexual assault cases. But, what should you care? Well, it's going to affect you or the people you know in about 1.5 years. So, not only do I encourage you to inform yourself on your university's sexual assault policies, if necessary and if conditions allow, we should all participate in protests and voting in order to voice our own opinions. These policies are designed to protect us, so we have the responsibility to fight for an impartial system. Thanks for watching.